Why learn about sexual harassment? Sexual harassment has become a much talked about topic in recent years, especially after the Me Too campaign, which was started in 2006 by Tarana Burke.
There are different types of harassment, but in this session, we will focus on sexual harassment in the workplace.
The Supreme Court of Canada, Jans and Platy Enterprises, 1989, defined sexual harassment as
Unwelcome conduct of a sexual nature that detrimentally affects the work environment or leads to adverse job-related consequences for the victims of the harassment.
This shows that harassment may include words or actions that may abuse or aggravate another person.
This session examines what a workplace is and what sexual harassment is.
What is an employment relationship? The Alberta Human Rights Commission states,
in general, an employment relationship exists when an individual earns their livelihood from that relationship. It has also been held that a person is an employer where the person controls, at least to some extent, the ability of a person to earn a livelihood. It is important to note that employment relationship can exist outside physical workplaces.
Workplace or employment conduct includes conduct that occurs outside regular work hours, such as on business trips, at company parties, or other work-related functions, but that has implications for the workplace. In other words, conduct or activities that occur outside of a workplace setting, but done in connection with employment, also constitute workplace conduct.
An example of this is conduct done at a company's staff Christmas party held in a hotel's banquet hall. Though the banquet hall is not the company's workplace, if sexual harassment occurs at the party, it qualifies as workplace conduct.
Employment relationships can exist outside our conventional ideas of what is employment. For example, human rights tribunals and the courts have found that independent contractors, taxi drivers, Army cadets, and volunteers to be in employment relationships under human rights legislation.
What is sexual harassment? Sexual harassment can be described as behavior that is sexual in nature and that is unwanted, abusive, and puts the recipient under some sort of pressure.
The Alberta Human Rights Commission describes sexual harassment as any unwelcome sexual behavior that adversely affects or threatens to affect, directly or indirectly, a person's job security, working conditions, or prospects for promotion or earnings, or prevents a person from getting a job, living accommodations, or any kind of public service. Sexual harassment is a type of discrimination. The Alberta Human Rights Act prohibits discrimination based on the following 15 protected grounds: race, color, ancestry, place of origin, religious beliefs, gender, gender identity, gender expression, age, physical disability, mental disability, marital status, family status, source of income, and sexual orientation. There are also 5 protected areas: employment, goods, services, accommodation, or facilities customarily available to the public, tenancy, representations including statements, publications, notices, signs, symbols, and emblems, or membership in trade unions, employers' organizations, or occupational associations.
Broadly speaking, discrimination includes any distinction, including exclusion, restriction, or preference based on a protected ground and in a protected area that results in harm to the recognition of human rights and fundamental freedoms. Discrimination is behavior that results in an adverse effect on the recipient of the discrimination and does not have to be intentional for it to be illegal. In Regina and Andrews, a Supreme Court case from 1989, discrimination is described as
a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed on others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society.
Types of sexual harassment. Sexual harassment may be displayed as verbal harassment, nonverbal harassment, or physical harassment. Sexual harassment subjects people to discrimination by restricting their ability to enjoy benefits and opportunities in the 5 areas protected under the Alberta Human Rights Act, including employment, goods, services, accommodation, and facilities customarily available to the public.
Physical harassment includes touching, pinching, patting, kissing, fondling, and grabbing. Physical assault can also be a criminal offense. Verbal harassment includes slurs, jokes, and derogatory comments, gossip about a person's sex life or partners, and sexually suggestive invitations. Nonverbal harassment includes leering in a sexually suggestive manner, displaying pornographic images, and suggestive/obscene notes or emails.
Sexual harassment can be unpleasant, upsetting, and unwelcome. Instances that do not qualify as sexual harassment. Sexual harassment is not mutually acceptable workplace flirtation, any sexual action that both parties consent to.
How can I tell if it's sexual harassment? You can tell it is sexual harassment if it involves any of the occurrences listed above. If you have any negative feelings or unease about the actions, do not ignore them as they may be an indicator that something is out of place or not quite right.
Does an action have to be repeated to be termed sexual harassment? The answer is no. A course of conduct or set of repeated actions is not required in determining sexual harassment in the workplace. A single instance can be enough.
Does an action have to be intentional to be termed sexual harassment? No. Sexual harassment is discrimination based on gender, and the courts have determined that discrimination does not have to be intentional for it to be illegal.
Is sexual harassment peculiar to only one gender? No. All genders can experience sexual harassment.
According to Statistics Canada, 2018, a 2016 General Social Survey on Canadians at work and home found that 19% of women and 13% of men reported being harassed at work. This includes unwanted sexual attention or harassment. Members of the LGBTQ community are also targets of sexual harassment at the workplace.
What is the test for sexual harassment? Through many human rights tribunals and court cases, the elements of the test for determining whether sexual harassment has occurred require conduct which is unwelcome when assessed objectively, which emanates from an employer, an employee, or an agent of the employer. The harassment was in the workplace, and the offensive conduct was due to the gender of the victim. I have been sexually harassed. Is this my fault?
Your physical appearance or the way you dress are not reasons for you to suffer sexual harassment at the workplace.
Summary: important facts about sexual harassment. Sexual harassment does not have to be intentional. Sexual harassment can inflict financial, emotional, or physical trauma on the victim. Sexual harassment is gender harassment. Sexual harassment at the workplace may be done by a coworker or by someone in a position of authority who can exert power over the recipient. Sexual harassment is discriminatory and is prohibited by the Alberta Human Rights Act. Sexual harassment may sometimes qualify as a crime prohibited under the Criminal Code.